mean, the notion that this woman, Shari Redstone, I mean, she's got plenty of money, okay? She could figure out a way to sell her shares. She doesn't need that $5 billion. It's just basically, we live in a society where people care about that extra $1 billion more than they care about their country. If I had a couple $1 billion, I would make Donald Trump's life so fucking miserable.
Hello, everyone. Welcome to George Conway Explains It All to Sarah Longwell. He's George Conway. I am not Sarah Longwell. I am JVL from the Bulwark.
We all aspire to be Sarah Longwell.
Don't we?
Yes.
Woke up this morning to news that Shari Redstone had settled the lawsuit with Donald Trump in 60 Minutes, in which the President of the United States alleged emotional distress.
Look, if you were Donald Trump, you woke up and you were Donald Trump, you would be emotionally distressed.
Fair enough.
So that's a lot of
damages because 60 Minutes edited and condensed the interview it did with Kamala Harris, because the show is only 60 minutes long, and then they have like 14 minutes of commercials. And anyway, I don't want to spoil it for Donald Trump. This, in theory, Shari Redstone believes will clear the way for her to sell her company to David Ellison and Skydance. She is projected to walk away from that with $1.5 billion. And I don't know, it just seems like another great thing. Has it ever been before the case that the courts have been used to launder bribe money? Because that does seem to be what this is. It is, instead of Shari Redstone going and handing a sack full of money to Donald Trump in order to curry favor, she has simply laundered that exchange through the courts so that it's all very cool and very legal.
Yeah, look, I mean, this isn't the first instance where an accusation has been made that a court settlement is effectively collusive and is designed either to cover up extortion or bribery. And I think the way you measure that, I mean, obviously, to prove that it is criminal and prove that it is objectionable, I mean, you need actual evidence of what people did and what they said and what they thought. And of course, that gets sanitized because people don't necessarily tell the truth when they are engaging in collusive activity to cover up bribery or extortion. I think here the biggest indicator is the complete and utter meritlessness of the claim. I mean, I've never heard of any claim, and I don't know how any claim consistent with the First Amendment could be made, even if there was a cause of action for it, that this somehow violated Donald Trump's rights. I mean, he can sue if he is libeled or defamed, slandered, and that requires basically a false statement made with what the Supreme Court has called actual malice, which is essentially the tantamount to the intent to lie about someone, and to lie in a manner that defames them. In other words, harms their reputation. That's pretty hard to do with Donald Trump. There really isn't any, I mean, you could say he's a sexual molester. Well, it's true, right? You could say he steals things. True. You could say he's an insurrectionist. True. There's really not a hell of a lot you can say about Donald Trump that he could recover damages for, even if this were an actual claim recognized in law.
Right.
And even under the First, and especially under the First Amendment. This is not a claim that was recognized under law. I mean, so somebody, if anybody might have a beef about it, it might be Kamala Harris, because she didn't get her full airtime, and all of the things that she said weren't heard. And there's no harm to Donald Trump. I mean, was there really an allegation that there was something in the outtakes that was so helpful to Donald Trump? Again, even if there were, it's just not a claim. So I think on its face, this settlement is highly questionable. But the problem is, it's people are entitled to settle their own lawsuits, and unless a prosecutor gets involved, and this would be something that a state prosecutor could possibly get into. It is illegal to bribe officials. It's illegal to lie to a court. It's illegal to extortion is illegal. Again, but hard to prove. And the thing that's interesting here is Donald Trump wouldn't have an immunity defense. And do you know why?
Why is that?
Because he's not going to assert that this had something to do with his official duties. First of all, he can't, because it didn't happen when he was president. And secondly, the settlement, he can't say that has anything to do with his official duties, because that would bring him one step closer to the elements of bribery and extortion that he would want to avoid. So this is a bit of a mess. I don't know that there's any way to rectify it absent some kind of a state law investigation. I mean, maybe there's a state law somewhere that is relevant that prohibits what are called gratuities, because gratuity is easier to prove than bribery. Gratuity is basically saying, giving something to somebody to say, thank you very much for the nice job you did for me. But in this case, he hasn't quite done it yet. It's not clear what he's actually doing to facilitate this merger, if anything.
Well, the FTC that signs off on it, not Donald Trump.
Yeah, so
if everybody just knows the score at the FTC, they don't have to be told.
Well, and that's what the funny thing about the FTC is. It's actually an independent agency, right? It's not run by. I mean, the president appoints
unitary executive, George.
What?
Unitary executive.
Well, that may be true someday. I mean, I think a decent argument in ordinary times, I would say, yeah, a decent argument can be made that the FTC shouldn't be constitutional. I don't like making that argument these days because we have problems enough with the executive that we have. So this is going to be hard to prove. I mean, the other angle could be just to sort of, and I think it may well be somebody tries this, is that there's a doctrine called corporate waste. It's a doctrine of corporate law. It would be a civil claim brought by shareholders of the company who would bring what is called a derivative action, where they essentially sue on behalf of the corporation to recover damages from the people who have done the corporation harm, which would be, in this case, the directors of Paramount. But the problem is going to be the question of harm. If it means that if this deal somehow did mean, I mean, first of all, the waste would be the outpouring of money, the 20 whatever million dollars. On the other hand, the defense would be kind of inconsistent with the defense against bribery and extortion.
Totally right. Yeah, no, they'd be the opposite.
Right. It's like we did a great thing for the company because we made sure by giving Donald Trump money that we got this deal through. So that's sort of like, okay, the defense would be kind of admitting to a crime, or almost. So it's sort of interesting. And what would be interesting about this, and I wouldn't mind seeing somebody do it. In my prior life, I did not practice law involving would-be dictators. Just wasn't a thing when I was in the practice of law. Yeah. So when I practiced law through 2020, by that time I was kind of phasing out. I'm an old guy. But before then, I practiced corporate litigation. I did securities class action litigation. I did contract litigation. I did some antitrust merger stuff. I also did I defended shareholder derivative actions, mostly of Delaware courts. And what's interesting about Delaware law, and I'm assuming Paramount is a Delaware company. It was a Delaware company when I was involved in one of the seminal corporate law cases involving an attempt by our client QVC to take over Paramount in 1993. So it was a Delaware corporation, and I assume it still is. One of the things under the Delaware General Corporation Law that's kind of an interesting provision is called Section 220. And what Section 220 allows is, before you bring a derivative action and make charges that the company has done something like waste money or engaged in, that directors or officers have engaged in self-dealing, is you actually get to ask for documents before you bring the lawsuit. And Section 220 is a provision that allows shareholders, like, do you own Paramount? No.
I mean, I could.
Oh, you could. Well, you probably would have had to own it last week through today, but you can make a request of the company to produce relevant documents, books and records they are called, but it would include emails and pieces of paper and whatnot, to see what happened here. It's kind of like a FOIA request for corporations, if you want to look at it that way. And in fact, the Delaware courts say that they tell shareholders and shareholder lawyers that before you bring a derivative action, use the tools at hand is the language they use. And the tool at hand that the legislature of the great state of Delaware has given you is Section 220. So I would look forward to, and I hope it happens, we'll see, some kind of a books and records request of Paramount to see what the heck happened here and how this came about. Now, one other defense that they're going to have, which is interesting, is apparently there was a mediation to settle this. And one of the things that's helpful to the potential defendants about a mediation is it provides an imprimatur that there were legitimate negotiations between the two parties at arm's length, and that there was a mediator who mediated. It helps the idea that this was a legitimate settlement. And I don't know what mediator they used here. There's some pretty good ones. I don't know whether they were involved here, but there's a lot of mediation occurs settling corporate disputes. There's a mediator's privilege, actually, because the law promotes settlement discussions and promotes mediations. And, that could be an obstacle toward figuring out what the truth here was. The bottom line is this stinks to high heaven, but there probably isn't going to be a clear remedy or clear way to dig at this to find out more about what happens, other than people yapping to the press, which actually may help an AG or a potential shareholder plaintiff's lawyer. We'll just have to see what happens here. It is absolutely an outrage. And if, I know some people are making money off of this, but that doesn't make it better. That makes it worse. It makes it really, the notion that this woman, Shari Redstone, she's got plenty of money. Okay. She could figure out a way to sell her shares. She doesn't need that $5 billion. It's just we live in a society where people care about that extra $1 billion more than they care about their country. And
that's for sure.
Yeah, it's if I had a couple $1 billion, I would make Donald Trump's life so fucking
miserable. Can you imagine? Yeah.
I would work for Elon Musk if he hired me to do that.
The point of having a couple $1 billion is that if somebody tries to extort you, you can tell them to go fuck themselves.
Yeah, no,
it's that's why you have it.
No, and it's sort of interesting because I grew up in the culture of New York. Grew up as a professionally of New York lawyers and investment bankers, and the investment bankers and the people who made money on Wall Street, they talk about fuck you money.
Yep.
Right. And it's like one of the things that's amazing, like if you become an investment banker, you work your ass off and you're under a lot of pressure. And then you retire at 40, okay, yep, with your fuck you money. And you can basically tell nobody can make you do what you don't want to do. But these people don't necessarily devote themselves to being able, to telling people to fuck off in a way that sort of redounds to their credit. It's funny. I clerked for a federal judge right out. I mean, lawyers don't make nearly as much money as these financial types, but I did all right. But when I left, I had a clerkship right out of law school with a wonderful federal circuit judge named Ralph Winter, who actually was considered to be put on the Supreme Court during the Reagan administration. It turned out that he was second on the Justice Department list and second on the White House list. And what happened was the person who was first on the list was Ginsburg. Remember Judge Ginsburg, who then, if they found out that he smoked pot with his
smoked weed with his students.
So then they went to the first person on the justice list, and it was Anthony Kennedy. And if we had ranked choice voting,
you would have been there.
Ralph Winter could have won. But anyway, Judge Winter advised his clerks and advised me, "What should we do, Judge? I want to become a prosecutor. I want to go work in the Justice Department as an intern, or I want to work in the White House as a deputy, like a junior thing, to do all these cool things that you can do once you get your law degree, but not make much money." And he basically said, and his experience was from friends who worked in the Nixon administration. He had a lot of friends who worked in the Nixon administration, including Bob Bork, his closest friend. And he basically said, "No, you don't want to do that. You want to make money. You want to go work at a corporate law firm so that when you do go into government and then somebody tells you to do something you don't think is right, you can just go away because you have the money to do that, and you already have an established career in the private sector." I don't know how that's all relevant to. It's relevant to what I was saying.
It's good. It's good advice. So here's my question for you as a pro. So you're a litigator. Litigators are competitive guys and gals. If you were on the legal team for Paramount looking at this suit, and corporate, I mean, I understand the client is always right, and corporate is like, "Nah, we're going to settle," would that chafe you unbelievably?
It would drive me batshit. It would drive me batshit. And it's a difficult position for a lawyer to be in.
To sign off on something that they have very good reason to believe stinks to high heaven, right? I mean, it's tough.
To high heaven, but their job is to try to make it legal.
Right. Yep.
And if there's a reasonable argument that can be made that it is legal, even if you advise the client not to do it, arguably you have a duty to try to carry it out. And the fact that lawyers
at the client putting you in that situation, though, right?
I would not be happy with the client. I mean, and it takes a lot of courage to basically say, "I'm not going to do this." Particularly, again, and we've had this discussion on here, I think with both you and Sarah, about how much these corporate deals pay lawyers.
Oh yeah, percentages, right?
Percentages, that's the point. And the percentages, that's the reason why some of these law firms capitulated to Donald Trump, because they were so afraid. I mean, there's a parallelism here. These law firms like Paul Weiss and the others settled because they were afraid, and probably their private equity clients or their other corporate bankers, the bankers that recommend them to corporate clients, were fearful that Donald Trump would figure out a way to spike their deals, and nobody would get paid. So it takes a lot of courage to stand up and say, I'm not going to, I want to turn down, or I want to avoid this fee. I'm not going to take this fee because it's something to do. It would require me to do something that's dishonorable, that I consider dishonorable and adverse to the nation's interest. And there's not precious few people are willing to do that.
It's a big ask. All right. Yeah. So yesterday, Donald Trump said something weird. He was asked about Elon Musk.
He said what?
Yeah, I know. He was asked about Elon Musk and whether or not he would attempt to denaturalize Elon Musk. And instead of saying, "What the hell are you talking about?" Trump was like, "Well, I don't know. Something we got to look into." And there's been a lot of denaturalization talk over the last 2 weeks now.
Yeah. No, I think on that one, I think maybe Donald Trump is finally making an effort
something
bipartisan.
So it actually began with a memo circulated to the civil division from, I forget who it was, from one of the higher ups at DOJ in early June, saying that wanted aggressive pursuit of denaturalization in every case where it could be made. And it's funny, there was in the memo, there's like a list of priorities to explain which gets priority. And you go all the way down to like number 10, and number 10 is for anything else you think. It's one of these, like, why bother if the answer is do it for whatever the hell reason you want? Why bother listening to priorities? Beside the point.
Why have law?
But this became to the fore because Andy Ogles, representative from Tennessee, sent a letter to Pam Bondi saying, I would like you to begin an investigation of Zoran Mamdani, the guy who just won the New York City Democratic mayoral primary, because I think that he should be denaturalized, potentially. And so I went looking into the U.S. Code on this, and these things are relics of the Cold War. So the relevant laws are passed in 1954, the height of the Red Scare stuff, real McCarthyite period in American history. And the law is shockingly open-ended on this. And so, one of the ways you can denaturalize or one of the reasons you can have for denaturalizing somebody is because they are requested to testify before Congress about subversive elements and they refuse. Which is, again, just straight, like, if Joe McCarthy subpoenas you, you have to show up. Otherwise, we can denaturalize you.
Bannon could have been denaturalized.
Yeah, I guess that's right.
If he had been a naturalized American citizen.
Right. And then the other is this giant big catch-all of anybody who has ever stood within 50 feet of the word communist or advocated for property damage or an economic system contrary to America, like wild stuff.
Yeah.
But again, it is so loosely worded that I don't know, in the same way that the Secretary of State can now look at a graduate student from Tufts and say that an op-ed that she co-bylined is grounds for revoking her visa. Mm-hmm. I don't know. Like, why is this law not wide enough to denaturalize somebody who calls themselves a democratic socialist? Right?
Well,
and who has said that they want to resist ICE and stuff.
Yeah.
It just feels like, I don't know, man. Like, they could give that the old college try.
They're going to try, right? They're going to, sooner or later, they're going to do something wild here like they do with everything else. But let me take a few steps back here. Yes, there was a lot of Red Scare era amendments to the immigration laws and the naturalization laws. The truth of the matter is, and this is without defending the current iteration of this, because they will push things so far as to make the prior practices unrecognizable. We know that they'll do that, or at least they'll make a show of trying to do that.
Right.
Because a lot of what they do is performative. Denaturalization is a thing. There is a lot of case law. And I haven't read this case law, and I'm not an immigration lawyer, but there is a lot of case law that you can dig into it relatively quickly because there's so much of it. Because it's something that the United States government does and should do. I mean, the most notable cases were, there are a couple of famous cases involving Nazi concentration camp guards who did not disclose or lied about what they did during the big WW2, and then were later found out to have been at Treblinka or someplace like that. And then proceedings were brought to denaturalize them. And then there are other cases where people just flat out lie about their eligibility. And, that's by far the most common situation where somebody we'll just say hypothetically his name is Elon Musk,
sure,
comes to the United States and he comes on a student visa or something, and then he doesn't. I forget which way it was in Elon Musk's circumstance, but then he starts working, which he is not allowed under the terms of the student visa, and then later he gets a green card and then it becomes a citizen. I mean, there's a, if the law is that if you make a material misrepresentation that gets you a green card or gets you a visa, that can result in denaturalization if you later become a citizen. That's all very legitimate. Okay. And, there was even an effort during the Obama administration to, I believe, to cut back on immigration fraud. I mean, it can come in very numerous contexts, like a fake marriage. You marry a United States citizen, but it is a sham marriage. There are all sorts of factual circumstances where it's legitimate to pursue denaturalization. Trump did it, for a bunch of different reasons in 2020. I don't know really what became of it, but there was a big to-do about it then. But this time, I think they are going to push it farther. Now, in terms of what the law says about communists, I don't think it's necessarily as broad as you make it is. It says things like, it actually says that if you are naturalized and within a certain period of time you join the Communist Party of the United States, that's pretty specific. I think just simply advocating views that might be deemed communist or socialist, or advocating the rights of Palestinians, or that even saying that, Palestine should be free from the river to the sea, I don't think any of that would suffice to get someone denaturalized. And the process is an onerous one for the government. The government has to actually file a civil lawsuit for denaturalization in a United States district court before an Article III judge, a United States district judge. It can't use its own immigration courts. It can't act summarily. And it has to prove, under a Supreme Court decision in the 1940s, that the evidence is basically clear and convincing and overwhelming. That may not be the quite exact language, but clear and convincing. You really have to prove a strong case to do this. There's a heavy, heavy burden on the government to do this. And it's hard to imagine that in the case of Mondani, they could really do that. But I don't speak to knowing everything that Mondani has done in his life. And if they did that, I think it would be more performative than anything else. In terms of Musk, I have to go back and look at what the facts are, but it does seem to be not disputed in the public reporting that he did make untrue representations in connection with his immigration status in the United States prior to his naturalization. Whether that can be overcome by other facts, I don't know. So, in other words, if I were Mondani, I wouldn't be worried, because not only because I don't think they can do anything to him, but because then he'll get to grandstand about it, rightfully. Musk might have a problem. I don't know.
Yeah, I feel about this the way I feel about the birthright citizenship executive order, which is, hey, it's so preposterous that this can't ever possibly happen. But on the other hand, they are trying.
Yeah.
And crazier things have happened.
Yeah.
Right? I mean, we never would have thought the Supreme Court would create a writ of presidential immunity. They did it. We never thought they would, got the 14th Amendment and make it so that insurrectionists can run for president. They did it.
Yeah, I mean,
I don't know, man. It makes me pretty nervous.
Well, and it should, because they're just, they just think of wild shit. How they can contort the law, distort it, ignore the law, rewrite the law, to do things that look good on TV, and things that are just cruel, and things that are just nihilistically insane. And that's what they do. That's their modus operandi. Sometimes it kind of works. Sometimes it falls flat, and sometimes it just makes a lot of people miserable. And that's where this is who they are, and this is what they do.
All right, so this brings us to last week's Supreme Court decision in Trump v. Casa, and I just want to put a quarter in the machine. Hear what you have to think.
Yeah, look, our liberal friends, many of them are apoplectic about the decision. And I had kind of a heated debate last week on MSNBC about it with Professor Melissa Murray of NYU, who I greatly respect and admire. And I actually had another one today, less heated, but I was sort of the dissenting view at a panel at Georgetown University on the rule of law, and then in the next panel, Dean Chemerinsky, a very prominent academic, then tried to rebutted me point by point, or gave the counter arguments. What this was about, and I think we've talked about this in the past, is the concept of nationwide injunctions or universal injunctions. And this is the thing is where you sue the government, JVL versus USA. Since we're doing DVD and AARP and all the other initials, it's JVL versus USA, saying that the United States has done something to you, like people wearing us Liberty Bell hats must be, expeditiously removed from the United States.
Yeah, not allowed in Wawas.
Yeah, and let's assume that there are a million other people wearing these same hats.
Yeah.
If you sue, and it's completely ridiculous that the government's trying to do this to you, what could have happened until Friday was you could bring a suit just by yourself against the United States or the State Department or the DHS probably, and they could enjoin the government from doing it to all you guys who bought Liberty Bell hats.
And I would file that suit where? Just in like my local district court?
Yeah, in the local. Where are you, in Virginia? What's your address?
Jersey.
Jersey. Oh, you in Jersey? I didn't know that. Okay. Go Birds. Yeah,
that's right.
Okay, go Birds.
All right. That's what this is, George. This is the City Connect.
Birds, Philadelphia, right? You're not a Giants
fan, right? This is the Phillies.
You're not a Giants fan, right?
No. Oh. I used to trick or treat at Randall Cunningham's house.
Oh.
True story. He gave out king-size candy bars because that dude was awesome.
Yeah, he's a great guy. So, the court would issue, the United States District Court for the District of New Jersey would say, yeah, this is freaking crazy. I'm enjoining the government from doing this to anybody, even though you were the only person in the lawsuit. And the question became, as the court took it last Friday, said, wait a minute. Historically, this wasn't a thing, right? Historically, if A sues B, A can get relief if A is right, but A can't get relief for all the other people like A who could have brought a lawsuit but didn't. Now, there are some emendations to that rule. Let's suppose you live in a housing development and there's somebody, there's a Giants fan throwing a party and it's too loud. He throws parties every night, all night, and you bring a nuisance action against him to get him to turn down his stereo and so forth. If you win and he has to turn down his stereo, all your neighbors win too, even though they didn't bring suit. Right. And there's a doctrine there of like, okay, it's called complete relief. If A sues, you sue, and to get relief for you means everybody else gets the benefit of it. That's fine. Okay. But historically, and this is this whole concept of a universal injunction where we're granting the individual plaintiff relief that it wasn't necessary to give everybody else in the world relief. It wasn't really a thing, although Dean Chemerinsky today said, oh, no, there was examples in the 1800s. I don't think there were many. It became a thing in the last 30, 40, or 50 years. And what the Supreme Court held was, and it became a very controversial thing to administrations of both parties. They were very annoyed by this. And when Obama was president and when Biden was president, you'd have the Attorney General of Texas, say, Ken Paxton in the last few years, bringing crazy lawsuits in I forget which district in Texas it is. I think it's the Eastern District of Texas before this judge, who's Ken Marzik, I forget, I could probably mispronounce his name. But you'd bring, red red state AG would bring a case in the Western District of Huzawazi and get Judge Cuckoo to enjoin the government from doing everything under the sun. Okay, and same thing with during during conservative administrations. The Democratic Socialists of America would bring a lawsuit in the Northern District of California, in San Francisco,
right.
To enjoin what the conservative government was doing. And, sometimes they're right, sometimes they're wrong, but what would happen is it's like, for the problem that was annoying to people in the Justice Department of both parties is you get a bunch of these lawsuits. They don't just bring in one case. They'll pick their cherry, but they'll bring one in Boston. They bring one in Minneapolis. They bring in, in liberal places, for example, if it's a claim that liberals like, or conservative places, red states, if the otherwise. And the government's got to win every single case, because if the government loses one case, it's a nationwide stop.
Right.
And it drove administrations crazy. And so this isn't something that just affected the Trump administration, although it really affects the Trump administration because it is orders of magnitude more lawless than any other.
Right, I was going to say
in the history of administrations. And the way the court went at this was to say, look, historically, you can't just have one person getting relief for everybody unless you have this complete relief situation where, redistricting or school desegregation, where you can't just say, oh, yes, you young black parents with the black student, you should be entitled to go to this nice school where they're all white people, but you can't really do that without reorganizing the whole system.
Right.
So what they did was they said, you have to, ordinarily, you can't bring this lawsuit to get relief for everybody else. And our liberal lawyer friends just think that is the end of the world. And the reason why I don't think it's the end of the world is I have sympathy for that view. And plus, there's like another procedural mechanism that was created almost 100 years ago and that developed from the old systems of class actions.
Right.
And there are different kinds of class actions. There's the B1 class, 23B1 class action, B2, B3. I get into the technical details. The kinds of class actions I used to deal with when I was a corporate litigator, as I mentioned before, was complex securities litigation class actions. And these kinds of class actions, like antitrust class actions, toxic tort class actions, they're complicated. Okay, they are hard to get classes certified, or at least harder, because there are issues of causation and who's in the class and when they bought their shares and what was the price of the shares when they bought, and so on and so forth. And those class actions are really freaking complicated. And to get a class certified, you have to hire economic experts who do economic event studies and so on. And it costs you, before you know it, costs you $500,000.
Right.
That doesn't exist in this kind of class action, like a kind of class action that was literally brought moments after the Supreme Court decided the nationwide injunction, the universal injunction issue in the birthright citizenship case on Friday. Those cases are simple. They don't, it's like, what does it say on the top of your birth certificate? Okay? Do you have something that says a U.S. jurisdiction or not? That's the only issue. Causation, damages, there are no issues. It's just basically, is the government screwing you or not? Okay, up or down. And not only that, it's not complicated like a securities class action where where the amount of damages or the claim gets better or worse depending on when you bought. It's like and what is fraudulent or what is false and misleading or whatever and material. This is like this is an up or down question on what 5 words in Section 1 of the 14th Amendment means, subject to the jurisdiction of. And a lot of the criticism from the left lawyerdom about, and I don't mean that pejoratively. I've come to
I understand
like
that.
Some of our left-wing friends have made common cause with them over time. They're thinking about all the ways the Supreme Court has cut back on class actions for damages and these securities and antitrust and consumer. It's like, I don't believe that's going to happen here. I think these class actions that have now been brought, that were brought Friday afternoon in lieu of the cases that were brought before, we're going to see classes certified very quickly, and we're going to see injunctions that are effectively nationwide injunctions very quickly, and the government's going to be back in the soup again. And I think that's the reason why the government didn't actually take up the merits of the case, because they know they're going to lose. I think what happened here was that the Solicitor General, Sauer, who was also the personal lawyer of Donald Trump in his criminal travails, but let's leave that aside, he wanted to give a victory to Donald Trump in the midst of all the losing that they have been doing at the Justice Department. And he picked this one issue that was sort of like members of the court had been expressing annoyance about over the course of time. And then they won, which nobody was surprised, least of all the people who were litigating against the government, because that's why they wrote these complaints that were ready to go with their revised cases. And then Donald Trump says, I forget the words he uses, is a great victory, and it's like the victory to end all victories. It's like, hey, I tell my liberal friends, like, listen, I know that upsets you, but I hate to break it to you, but Donald Trump lies. And he's lying about that the same way he lied about being totally exonerated in the Mueller report, and the same way he lied about the total obliteration of Iran's nuclear program.
And his 9-0 victory in the Supreme Court. Yeah.
The 9-0 victory. Yeah.
So let me play devil's advocate here for a minute.
You're good at that.
Because I want to believe, I want to be with you. But the two things that gnaw at me are why now and why this, right? If the problem really is this high-minded, very hands-off, just technical thing that we don't think this is the way that these things should be administered and whatnot, why didn't this result come in year 2 of the Biden administration?
Yeah, that's a legitimate, and that's the thing that's one of the things that really sets off our liberal friends, and it's one of the things that gives me pause. I would not have picked this case to do this in. And that's
the other thing. Yeah. So that's the other thing I was going to ask you is, again, if it's a highly technical thing, then I might want to render this sort of judgment in a case where the government isn't 100,000% in the wrong.
Yeah.
It's just prima facie, right?
And
to do this there and that, again, it just makes me go, maybe there actually is something different going on here.
Yeah. And that, look, I mean, I can't fully exclude that, although I would bet a very large sum of money the government is going to lose the birthright citizenship case. But yeah, I understand that concern. And I think one of the legitimate beefs of, it's funny, it's just, I just literally left Georgetown this morning where they were going off on this exact point, is like they totally had no problem with nationwide universal injunctions when it was Joe Biden's administration that was being joined. I'm not sure that's quite true. I think there were some suggestions that some justices made, like, we got to look at this more closely. And I can't. I'm engaging in speculation, and here possibly Pollyannish speculation here. Okay, this is what I hope was going on.
Sure.
Either they're just completely oblivious to the circumstances, which I don't think they are, or I think they realize that they're in a tough pickle. Right? It's easy for district judges to basically just enjoin the guy left and right because they don't get the last word.
Right.
And I don't mean that to be critical of district judges, because I think the district judges in the United States district judges, almost to like 100%, have been absolutely stellar and courageous and brilliant in the way that they've been handling these cases against Trump, and incredibly hardworking, turning out exquisite opinions overnight. And I cannot say enough about the federal judiciary. The Supreme Court, at the end of the day, is the one that has to face down the administration. When push comes to shove, when one of these cases, really, really hot button cases, comes up there on the merits, they're the last word. And if, and there's a decent chance, as I've been saying, here maybe I'm Cassandra instead of Pollyanna, that they're gonna tell the court to fuck off sooner or later.
Oh,
I
yeah.
really do believe that.
That's going to happen.
I think it's in their character, and I think, we saw a little about that in the whistleblower letter. Did we talk about that last week? Where
we did.
Beauvais is basically saying we're going to have to tell them, fuck you.
Yep.
I don't remember saying that. Using the F word a lot here. I don't know.
Because Sarah's not here. We can do whatever we want.
So I think here again, I'm not saying this happened, and this is maybe wishful thinking. I think they wanted to give them something a little bit. It's sort of like in the way, it kind of like it's the flip side of Sauer taking this up to sort of at least save some face with the boss.
Okay.
And look, the government asked for it here. And the government asked. I mean, you don't get anything unless you ask, and the government asked here. And again, but that doesn't fully answer it, because it is, it did have a bad look when they granted it. I absolutely, well, not they granted it, when they set it wasn't a cert grant. It was a stay application on the shadow doc, what's called the shadow docket. And they set it down for oral argument, which they almost never do. Okay, stay applications and applications for injunctions pending appeal, all this stuff that doesn't actually involve the actual case heard and social search. It's just the emergency stuff. They never hear oral argument on it. And they did that here. And not only did they hear oral argument about it, they heard oral argument about it in May. They don't hear oral argument I think it was May. They don't hear oral argument in May. They stop in April. And then they work on the opinions, and then they go home in June. So this was a highly, incredibly unusual intervention that it is precious. It is weird that it happened in a case where the government is just not only just 1,000, 10,000% wrong, but egregiously and immorally and atrociously wrong in a way that I don't think there are enough adjectives to describe.
I'll tell you why my spidey sense is really tingling on this.
Yeah.
And it's because of the two cases we had in the summer of 2024. The first one was the Insurrection Act case, in which we thought, we meaning like the general people in our world, like, I don't know, he's dead to rights. What are they going to do? Right. And then it turns out that they made this cockamamie ruling where they, invented a thing that Congress would have to do in order for the Insurrection Act. And we couldn't understand, like, why are they doing that? They're enabling him. And the answer was they were enabling him then so that they could totally alibi him when he came up to them for the next thing on presidential immunity. And that is what worries me. Like, no, we never thought that presidential immunity was possible. Right. We didn't think that. We just thought that's a thing that the Supreme Court is never going to give him. And I worry that we're thinking about that way on birthright citizenship. Like, oh, it's crazy. They can't, it's plain text. It's right there.
Well, I wish I could say you were absolutely totally wrong. I think you are absolutely totally wrong, but I can't. I hope you are totally wrong, but I can't say for absolutely.
We'll find out. The good news is we'll find out one way or another.
Let me just sort of, since you brought those cases up, I was strongly of the view that the Insurrection Act claims were, the Insurrection Act, the 14A section, the 14th Amendment Section 3 claims about disqualifying Trump for having fostered an insurrection were absolutely correct. And I went on TV and I said, yes, they should win. They should win. But if you ask me point blank, do I think he would win? And you gave me the truth serum, I'd say, I think they're going to chicken out. And they did chicken out. And in the defense of the conservatives, the liberals chickened out too. It was 9-0.
Yep.
It was you got 9 justices who were too afraid to read the plain language of Section 3 of the 14th Amendment by its terms, and worrying about things that, about, oh, well, what happens if one state does this and another state does this, worrying about something like, we had a president who engaged in a fucking insurrection. Okay? Let's not worry about all the other shit, like whether or not it's uniform. But they were scared to do it. And the opinion was so nonsensical that you can only attribute it to fear. Now, in the immunity case, I became convinced. First of all, I thought they should never have taken it, because I thought there was a way to review the immunity claims after he had been convicted and sentenced.
And plus, the appeals decision was hot fire. Remember, I forget who wrote it, but it was so good.
But it was it was hot fire, and it was great. And I thought it made perfect sense. And it's like, I did come to the conclusion before the case was argued that there was an argument that you had to kind of leave a little play in the joints for some kind of immunity where, I don't know, an insane Republican Congress passes a law to put Joe Biden in jail or something,
right?
Or it does something, that's really kind of out of line, that's really directed at punishing the president for just doing his job, making something a crime. Like, I don't know what it would be. And they could have done that without doing what they did. And the problem with what they did, I think, isn't this so much that it helped Trump, because I actually don't think it would have helped Trump on the merits of the case, because he did plenty of things that were not within the scope of the immunity that the Supreme Court created. So I didn't like the immunity decision. I didn't get completely upset about it. The thing that bothered me about it, one of the things that really bothered me about it more than how they kind of reached out to try to create a standard for all time unnecessarily, that probably doesn't make any sense, is that they allowed him time. They allowed him to delay that trial. Yeah. And that's why we are here today.
And they punted, again, it's not just the decision, but the way in which they reached the decision, they waited for the clock to run all the way out at every step. Yeah. Like, they didn't move expeditiously. And
I don't know, someday it's going to be very, very interesting when somebody donates their papers. I might not be around, and you will be, you're a young guy. The way Justice Blackmun did. Someday there's going to be a whole warehouse of papers of these people, and we'll get to see kind of what happened.
Yeah, like Raiders of the end of Raiders of the Lost Ark, where he pulls back an entire warehouse full of things. Yeah. All right. So, George, I'm afraid that this is the part of the show where we're going to have to go behind the paywall. And for the conversation about Alligator Alcatraz, everybody's going to have to follow us over there as subscribers. So
you're going to have to swim through the Everglades and pay a fee.
With the alligators with freaking lasers on their heads. So come and join us on the other side, guys.
Well, George Conway, he's a man with a plan. Got to sit down with Sarah Longwell, take a stand, explain all the legal problems they're piling high. With Donald Trump, oh my, oh my, oh my. He said, Sarah, let me break it down for you. There's obstruction of justice, corruption.